Thank you very much, Karima, for the introduction, and thank you as well for inviting us to be here with you today. It is a real pleasure. As Karima mentioned, my name is Natalie Drolet, and I'm joined here by Ravneet Riar, who is a staff lawyer at Migrant Workers Center. She started off as a volunteer and then worked with us as an articling student through a public interest articling fellowship. And then as a staff lawyer. We are both joining you today from the traditional, ancestral, and unceded territories of the Coast Salish peoples, including the Squamish, Tsleil-Waututh, and Musqueam nations. So for those of you who may not be familiar with the Migrant Workers Center, if we could go to the next slide. We were founded in 1986 as the West Coast Domestic Workers Association, and the Migrant Workers Center is a nonprofit organization that provides free legal assistance to migrant workers across the province of British Columbia. Our main office is located in Vancouver, but we also have a legal team dedicated to providing services to migrant agricultural workers in the Okanagan region, and the organization has a province-wide mandate. Now, in addition to providing direct services, we also advocate for fair immigration policy and improved labor standards through law and policy reform and test case litigation. One of our successes is that in 2016, we launched a campaign to push the government of BC to enact new legislation to better protect migrant workers from abuses in their recruitment to the province. And the result of this was new legislation called the Temporary Foreign Worker Protection Act, which was enacted in November of 2018. So we'll touch briefly on that later on in the presentation. And then I also wanted to mention that in April 2020, in response to the COVID-19 pandemic, we launched the Amnesty for Undocumented Workers campaign to urge the Government of Canada to create new pathways to permanent residence for essential workers. And we did have a partial success with that campaign as well, with the temporary resident to permanent resident pathway to permanent residency, which we will also cover in this presentation. And finally, I just wanted to mention that the Migrant Workers Center is unique in that our bylaws mandate that a majority of our board of directors is comprised of migrant workers, and as such, we are a worker-led organization. So I'd like to talk about some examples of the legal services that we provide. We assist with some immigration applications for permanent residency, work permits, visas, and we help people to restore their status in Canada if they've lost status. We also assist migrant workers who face labor exploitation to apply for open work permits for vulnerable workers, as well as temporary resident permits for victims of trafficking in persons. And we also can assist individuals to file claims for employment-related violations, including before the Employment Standards Branch, the Human Rights Tribunal, WorkSafe BC, and Small Claims Court, among others. And then finally, I just wanted to mention that we have a project called the Respect at Work Legal Clinic, through which we provide summary legal advice to newcomers who have faced workplace sexual harassment. And this particular program is open to any newcomers to Canada and not just temporary foreign workers. Okay, so today we are going to try to get through some pretty ambitious material here related to immigration law and employment law. Our goal is to provide an overview of some immigration options and issues for temporary foreign workers, including some of the recent public policies related to COVID-19. Often immigration is of chief concern to temporary foreign workers. They are often very concerned with their status in Canada and their ability to remain here, to continue working, or eventually become a permanent resident. So we thought it would be important to cover some of those issues. And then we will also look at some employment law related issues as well. Our presentation is not meant to be comprehensive. We could easily dedicate an entire presentation to any one of these areas. So what we're aiming to do today is really to provide an overview of some of the important issues and options for justice for migrant workers to be aware of. And To contextualize the presentation, I do want to just touch on some of the risk factors for temporary foreign workers. Temporary foreign workers are among, if not the most vulnerable workers in our province. And on this slide, we can see some of the reasons why this particular population is quite vulnerable to experiencing abuse in their employment in our province. So migrant workers can be vulnerable if they come from a country of political or economic instability and seek to have a better life here. And then there are structural aspects as well to the temporary foreign worker program, which create vulnerability to abuse. So in particular, having precarious immigration status in Canada, meaning immigration status that is temporary and tied to an individual employer, in addition to the work authorization that is tied to a single employer, a single type of job, and a single location, really creates power imbalances that are quite heightened and that can result in people experiencing vulnerability to abuse. Often migrant workers are socially isolated. They're new to the country. Some migrant workers are physically isolated as well, particularly if they work in rural areas on farms, such as agricultural workers. We also see isolation with the in-home caregivers as well, who work in private dwellings. There also may be language barriers. They may be unfamiliar with Canadian laws that govern their employment and their immigration status. They also have limited access to information and services. For example, when they come to Canada, they are not provided with information about their rights or where they can go for help. And then there is also a lack of monitoring and enforcement of the rights that do exist to protect temporary foreign workers. As I'm sure you're aware, the Canadian legal system relies mainly on complaint-based systems of enforcement, and migrant workers, for a number of different reasons, are often unlikely to utilize those complaint-based mechanisms for fear of, speaking up, for fear of losing their employment and fear of potentially having to be removed from Canada if they are unable to maintain their status here. So on the next slide, I'd like to talk just quickly about some of the impacts of the COVID-19 pandemic on migrant workers. So you may have noticed that since the start of the pandemic way back in March 2020, which feels like not that long ago, but it was, almost 2 years ago now, that there was an unprecedented amount of media coverage on temporary foreign workers and the ways in which the pandemic was impacting them. We saw that migrant workers were at a heightened risk of exposure to COVID-19 and of contracting COVID-19, and particularly amongst the agricultural workers. One of the first major outbreaks in British Columbia was at the Bylands nursery in the Okanagan and involved a large group of temporary foreign workers there. There were also close to 2,000 infections amongst migrant agricultural workers in the province of Ontario. And then we also saw that we witnessed a heightened employer control over workers during the pandemic. So in many ways, the pandemic only exacerbated the vulnerabilities that already were present in the structure of the temporary foreign worker program. And we saw the pandemic being used as a pretext by employers for imposing even greater limitations on workers' rights under the guise of promoting health and safety. So for instance, for migrant workers who are provided housing by their employers, so the in-home caregivers who may be living in the home with their employer where they work, or the migrant agricultural workers who are provided with housing on the farms where they work, we were seeing that these workers were being unlawfully confined to those areas and not allowed to leave for fear that they would, contract COVID-19 outside of the household or outside of the farm and then bring it back to infect, others. And this is true even after the 14-day quarantine period. And then we also saw that migrant workers were at a heightened risk of termination from employment, as well as losing their status in Canada. So we saw a lot of layoffs in certain industries, which was true for Canadians writ large, right? But for temporary foreign workers, if they lose their jobs, they could also lose their status in Canada when their work permits expire. So we found that folks were having trouble securing new jobs and jobs for employers who were willing to go through all of the steps that are required to hire a temporary foreign worker, including the labor market impact assessment process. And if someone lost their status during the pandemic, they couldn't legally work to support themselves. They could not access COVID income support benefits or renew their healthcare coverage. We did see some public policies being brought in by Immigration, Refugees and Citizenship Canada to try to address these types of impacts on temporary foreign workers. But in our view, they did not go far enough. They did not really address the fundamental problems with the program. They very much reinforced, the status quo of making sure that my temporary foreign workers are only getting work permits that are tied to a specific employer. They did not allow workers, for instance, to apply for open work permits if they had, lost their employment due to COVID-19. So on that note, I'm going to turn it over to Ravneet to talk about some updates on those public policies.
Hi, everyone. My name is Ravneet. And as Karima very kindly mentioned, I'm a staff lawyer at the Migrant Workers Center. So as Natalie was talking about, we've seen a severe impact of the COVID-19 pandemic on temporary foreign workers. There have been some policies that IRCC has launched in response to the pandemic. So while a lot of them have not been sufficient, there are a couple that I think are relevant for our discussion today. So the first policy that I want to discuss is a public policy that allows visitors to apply for a work permit within Canada. So in ordinary circumstances, visitors can't apply for a work permit from within the country. But due to COVID-19, the visitors are allowed to apply for a work permit. And this policy is going to be in effect until 28th of February, 2022, so until next year. I have on the slide right now the eligibility criteria to apply under this public policy. So a temporary foreign worker would have to remain in Canada with valid status after they apply for the work permit. They would also need to apply for the work permit before February 28th, 2022, which is when the policy ends. They also need to be a visitor with valid status when they apply for the work permit. And as I mentioned on the slide, that does include maintained status, which means that if a worker lost status and then they were on a visitor status, and when their visitor permit is about to end, they may have applied to extend their visitor status. So the period where they're waiting for a decision on their, the extension of their visitor visa, that's called maintained status. That still gives them valid status in Canada. So in those circumstances, they can apply for a work permit. And the public policy, there are more details about the public policy that are available on the link on the slide. And so it's a pretty helpful link. Under this policy, temporary foreign workers who are on visitor status and apply for the public policy, they can also apply for interim authorization to work using a web form. So that means that while their application is in process, they can make a request to work while the decision is being taken. So if there are any questions on this policy, feel free to put them in the chat. I know that the criteria can sound a little complex, but I'll now move on to the next public policy that I want to discuss today. So this public policy allows applicants to apply for interim work authorization. So due to COVID-19, applicants don't need to work until their work permit application. They don't need to wait until their work permit application is approved if they want to apply, for a new job or work with a new employer. They only need an email from IRCC saying that they do have the permission to change jobs. So essentially, the process is that the applicant would need to make a request through the web form. there is a specific template that IRCC provides that's available on the link on the screen. So they use the template and they would make the request through the web form. In response to the request, they would get an email or a response from immigration saying that they've been given permission to change jobs or work for a new employer. So the objective of this public policy was to allow workers to more quickly start working in a new job or with a new employer. Because typically processing of work permit applications can take anywhere between 3 to 6 months, sometimes even longer if they were on paper. So the purpose of the public policy was to ensure that workers are able to change jobs or work for the new employer without having to wait for 3 to 6 months. This policy has been in effect since May 12th, 2020, and it does remain in effect until it's revoked. In order to be eligible for this public policy, the applicant would have to be in Canada with valid temporary status. So that could mean a work permit. They should have held a work permit or were authorized to work without a work permit when the application was submitted. They would need to, in fact, submit an employer-specific work permit application. So it only applies to, if you're making a work permit application for a specific employer, not for people who are applying for an open work permit, such as a postgraduate work permit. Also, they need to apply for the public policy exemption using the web form, as I was describing previously. So that's the eligibility requirement for this public policy, and it remains in effect. The next public policy that I want to talk about is actually not in effect any longer. So immigration had a public policy for restoration of status. The policy ended on August 31st of 2021, and it has not been extended. So before I go into explaining the policy, in regular or ordinary circumstances, workers would have 90 days after the expiry of their status to apply for restoration. So in case a temporary foreign worker lost status, which means that their work permit expired, they would have 90 days from the loss of status to apply for a restoration. And they could restore to, by applying for a new work permit or a visitor visa. Under the COVID-19 public policy, this period for restoration was extended. So unlike the typical situation where it would be 90 days, workers were given a longer period of time. They could restore their status until 31st of August, 2021. But as of September 1st, 2021, this policy is not in effect. It's not been extended. So now temporary foreign workers would have to restore their status within the 90-day period, as was the case before the pandemic. However, in my view, this policy should have been extended. I think the solution was very short-lived. As we're all aware, the pandemic is still ongoing. The impact on employment is still being seen. So it has been difficult for temporary foreign workers to obtain new employment. So the extension of the restoration period was helpful because it gave them that extra time to, if they'd fallen out of status, to find a new job and then restore their status. But this policy is no longer in effect. So it's important for temporary foreign workers to know that they still only have 90 days if they lose their status. Now I'm going to quickly change gears and very briefly talk about the entry requirements for temporary foreign workers. There's been a lot of changes in this area due to the pandemic. There's been a lot of changing rules and regulations by IRCC. At this point in time, temporary foreign workers may enter Canada if they qualify as a fully vaccinated traveler. So I have a link here on the slide which explains who qualifies as a fully vaccinated traveler. But very simply put, it means someone who's received 2 doses of one of the government-approved vaccines, and they should have taken the second dose 14 days prior to their travel to Canada. The details can be found on the link there. If temporary foreign workers do not qualify as fully vaccinated travelers, they may still enter Canada, but only if they're coming for a non-discretionary purpose. or if they meet one of the travel restriction exemptions. So when we talk about non-discretionary purpose, there is a specific meaning that IRCC has for that. I'm not going to go into the details because it can be fairly complex, but an example that I do think would be helpful today is that if a worker has a valid work permit and they normally live in Canada, then them returning to the country would be a non-discretionary purpose. And that's laid out on the immigration website. So for example, if there's a temporary foreign worker who typically lives here, even if they're laid off, but they do ordinarily live in Canada, they can return to the country. There are also some other purposes that are described, but I'm not going to go into that today. But this is just for your information that they are able to enter the country. But of course, as I have on this slide, the regular travel document requirements do apply. So for example, typically workers would need their work permit or a letter of introduction, and there are a lot of other documents as well that workers are required to have, for example, their job offer. So all of those requirements continue to apply right now as well. Also, fully vaccinated travelers have some exemptions. They are exempt from quarantine and the COVID-19 testing on day 8. So that exemption does exist for vaccinated foreign workers. I have on the screen here a really helpful link, it's like a little quiz that IRCC has created, which helps temporary foreign workers to understand if they're eligible to travel to Canada. The discussion on what is a discretionary purpose and all of that can be fairly complex. So this quiz asks some standard questions which workers can answer, and then they get a response on whether they're eligible to enter the country or not, and what sort of documents they may require. So this could be something that could be helpful for temporary foreign workers. I now turn it over to Natalie for the next, for the pathways to permanent residence.
Yeah, thank you. So now we're going to talk a little bit about some of the pathways to permanent residence that do exist for temporary foreign workers. And just to provide some context to those pathways, IRCC has implemented a number of pilot projects and programs in recognition of the lack of pathways to permanent residence for most temporary foreign workers. So for example, there are current temporary and pilot programs for caregivers, for Atlantic workers, for rural and northern workers, agricultural workers, construction workers in the Greater Toronto Area, and asylum claimants working in healthcare during the pandemic, as well as the pilot for essential workers. But most of these programs and pilots, miss most of the workers currently in Canada, despite these programs. And many of the programs introduced are done so through ministerial instructions as temporary measures, which is why they're called pilots. The maximum amount of time that a pilot program can exist if brought via ministerial instructions is only 5 years. And many of the programs do not have, are not accessible to workers who have lost their status in Canada. The vast majority require workers to have legal status. Many of them also tend to set rather high language and education requirements to become permanent residents, and just that, all of these pilot programs can be quite confusing to workers. And given that they are introduced as pilots, they tend to also change, which creates quite a bit of misunderstanding and confusion in the community. So let's have a look at the temporary resident to permanent resident pathway on the next slide. Okay, so this is the most recent PR pilot introduced by IRCC. It opened on May 6, 2021, and it ends on November 5th, 2021. So there's only a few weeks left, or just under 3 weeks left for this pilot. And as I mentioned in at the outset of this presentation, the Migrant Workers Center was heavily advocating for pathways to PR for essential workers during the pandemic. And so we see this as a win. It is a step forward, that this pathway came into being, but it is very, very time limited. There is a list of occupations online that you can find by clicking on this link. For occupations that are eligible under this program, and there are several occupations. Currently, part of the pathway is closed, part of it is still open. So they're under the English speaking stream. There was a cap of 20,000 applications that would be accepted and processed for workers who are working in the healthcare sector, and that pathway remains open. So if you do have clients who are temporary foreign workers working in the healthcare sector, including as home support workers, they may be able to apply under this pathway. There was also a cap of 30,000 for workers in all other essential occupations, and that cap was reached rather early on. I think it was July, if I'm not mistaken. So unfortunately, that pathway is closed. There was also a stream for French-speaking applicants, which did not have a cap. And so if you have clients who would be able to take a language test in French and achieve the appropriate language benchmark, they could apply under the French-speaking stream. All of the pathways require 1 year of work experience or the equivalent in part-time hours completed in the last 3 years. There is a requirement to undertake language testing and obtain a result of Canadian language benchmark number 4 in either English or French. And there is no educational requirement. So applicants are not required to undergo an educational credential assessment, for instance, of their education in order to be eligible under this program. So the next slide I'm going to talk about is the home child care provider pilot and the home support worker pilot. So these are 2 pilot programs that came into being in June 2019, and they are going to be open for a period of 5 years until June 17th, 2024. Canada has a long history of offering pathways to permanent residence for in-home caregivers. I think since I started with the Migrant Workers Center about 7 years ago, we've gone through 3 different programs. So this is, a stream that where we've seen a lot of change in recent years, and we will, see another change in June of 2024. There is a cap of 2,750 applications that will be accepted and processed by IRCC for each pilot for each year. The home child care provider pilot reached its cap in April of 2021, which means that if you have clients who are home child care providers who meet the requirements for permanent residency, they will not be able to submit an application until January of 2022. The home support worker pilot, however, is still open. So these 2 programs are NOC-C, are for NOC-C occupations, the NOC 4411 and 4412. There is a language requirement, which is Canadian Language Benchmark Level 5, so slightly higher than under the temporary resident to permanent resident pathway. And there is an educational requirements. The care providers need to have completed 1 year of post-secondary education or higher in Canada or its equivalent, and they must have a credential. So they must have actually received a degree or a diploma or a certificate for their education to be assessed as being equivalent. And under these pilots, some of the interesting features include that applicants can apply for an occupation-specific work permit rather than an employer-specific work permit. And their spouses and children can also accompany them to Canada and apply for open work permits. So these are new features. Previously, the care workers who came to Canada received employer-specific work permits and were under the temporary foreign worker program. Now they are under the International Mobility Program. And there is no labor market impact assessment required. So if they complete 24 months of work in Canada under either occupation, either home childcare or home support, and provide proof of that work to immigration, they can apply for permanent residency under these streams. The next stream that we're going to look at is the agri-food pilot. And this is the, oh, sorry, Revneet, you were going to cover this one.
Yeah, absolutely.
Sorry.
No problem. So another stream that we wanted to talk about today is the agri-food pilot. This PR program is a 3-year program that was launched in May 2020. And so it will be open until May 2023. This stream is essentially for experienced and non-seasonal agricultural workers who work in certain specific industries and occupations. So, for example, some of the occupations would be meat processing laborers or general farm workers, farm supervisors. So those are the sort of occupations that are eligible under this pilot. And some of the industries are, greenhouses or cattle ranching, things like that are applicants who may be eligible under this pilot. There is a language requirement for this pilot as well. It's Canadian language benchmark level 4. And there's also an educational requirement, which is that the applicant must have completed secondary education, either in Canada or outside with educational, like with a credential, as Natalie mentioned, which is applicable for a lot of PR programs. Also, the applicants must have a job offer from their employer. So those are some of the eligibility criteria for this PR stream. The last PR program that I quickly want to touch upon today is the BC Provincial Nominee Program for entry-level or semi-skilled workers. This can be relevant for a lot of temporary foreign workers. 9 months of work experience is required in the eligible occupation with the same employer. So this is an employer-led immigration process. Some of the eligible occupations are in tourism and hospitality, long-haul trucking, food processing, etc. Under this PR program, the job offer from the employer must remain valid throughout the registration and the application process. There are also requirements for secondary education, as well as licensing or certification if that's required for the job. So this is also one of the possible options that temporary foreign workers can access. Now I turn it back to you, Natalie, to talk about some of the remedies for protection by immigration.
Yeah, thanks. So we're going to talk about some of the remedies that are available for temporary foreign workers who have experienced abuse in connection with their employment in Canada. So the first one that we're going to discuss is the Open Work Permit for Vulnerable Workers program. So often workers who experience abuse do face challenges with their immigration status. Their status may be tied to the employer that has exploited them. They may be undocumented, or they may have breached different provisions of the Immigration and Refugee Protection Act, such as doing unauthorized work. They may have lost their status and done unauthorized work if they were coerced by their employer to perform work that violated the conditions on their work permits. So if individuals have experienced abuse, there are currently 2 recourses for them to access temporary status or temporary protection in Canada. So this is the first one. So temporary foreign workers can receive an open work permit, which means that they can work for any any employer, does not tie to a specific employer, with urgent processing if they are currently experiencing abuse or face a risk of abuse in the context of their employment in Canada. And abuse, according to the guidelines for this program, includes physical, sexual, psychological, or financial abuse. It is only available to workers who have valid status in Canada. So either they must currently hold a valid employer-specific work permit or a work permit that's issued under the Seasonal Agricultural Worker Program, or they are on implied status, or what is now known as maintained status, meaning that they applied to renew their employer-specific work permit before that work permit expired, and they are waiting for a decision on that application. The duration of the open work permit can be for up to 12 months. It is also available to the applicant's spouse or children if they are in Canada. There are no application fees for this application, and there is a target processing time of 5 days. If a worker has performed unauthorized work, the guidelines state that this will not be a barrier for them to receive the work permit. And currently the processing times are exceeding 5 days, and that is true throughout the pandemic. We've seen processing times of more likely 1 to 2 months for these applications to get processed. Also, an interview may be required, either in person or by telephone. And renewals are possible, but will only be granted if the applicant's previous employer-specific work permit is still valid and they continue to experience abuse or be at risk of abuse. Just a note of caution with these, we've done a few access to information requests, and we have found that about 50% of applications across the country have been successful and 50% have been refused. So that speaks to a need, I think, for legal advocates and representatives to be sure to try to put together an application that includes evidence of the abuse that the individual has experienced. So we'll talk a little bit more about some tips on how to put these applications together in a couple of slides from now, but I'd like to turn to the temporary resident permits for victims of trafficking in persons. So this is the second remedy for temporary protection that is available to individuals who've experienced abuse. And here it is specifically for victims of human trafficking. And here we are mainly concerned with labor trafficking, so human trafficking for the purposes of forced labor. And this permit allows victims who have, or survivors who have lost their status in Canada or who are inadmissible to Canada, to regain their status. And if they are successful with their application for a TRP, they can also access interim federal health care, social assistance, and they can apply for an open work permit as well. So this is available to migrant workers who have experienced fraudulent or coercive recruitment for the purpose of exploitation, who've experienced labor exploitation and/or restrictions on their freedom. And TRPs can be issued to allow the migrant worker to reflect on what they want to do to stabilize their lives, recover from physical or mental trauma, escape the influence of their traffickers, and/or facilitate their participation in an investigation or prosecution. They are usually issued initially for up to 6 months, but they can apply for a subsequent TRP if they meet the eligibility requirements for the subsequent application. And there are no application fees for the first application. So in our experience, these permits are difficult to get unless law enforcement is actively investigating their case, or if there is an ongoing prosecution. So this is a program that was that has been around for, I think, since 2006. And There are ministerial instructions that guide the program, and they actually state that the objective is to provide, a safe space for people to, decide what they want to do. But what we've noticed is that officers, have turned to considering whether there is some kind of law enforcement investigation, and more officers are looking for really hard evidence of human trafficking, which can be difficult, right? Because a lot of our clients are reluctant to report to police for fear of being deported from Canada. So it's really important for individuals who are without status to understand this process and the implications of being granted or denied a TRP. If they are given a TRP, they will have legal status in Canada, and they'll have access to the benefits that I described. But if they are not issued a TRP, they may be required to leave Canada. And so people do when they do apply for these, they do so at great risk. So the next slide just compares kind of the difference between the two. On the left side, we have the VTIP TRP, or the TRP for victims of trafficking in persons. And on the right side here, we have the open work permit for vulnerable workers. And this just gives you an outline of the legal test that immigration officers utilize to decide whether to issue these permits. So notably for the TRP, there is a two-part test. So firstly, the individual must present evidence that they might be a victim of trafficking in persons. So they must provide evidence that either their recruitment was coerced or fraudulent, or that they were coerced into employment or another activity, or they experienced exploitative employment conditions, or their freedom was restricted. But even if they manage to prove that they are a victim of trafficking, that is not enough to receive the TRP. They also have to demonstrate that there is a purpose to be issued a TRP. And where the purpose, as I outlined on the last slide, include things like that they might need time to recover from trauma, or they might need time to, to have a period of reflection to decide what to do, or they might need time in Canada to participate in an investigation. And where we often find applications failing is on this purpose test. We see officers refusing applications on the basis that there is not a criminal investigation in process, and therefore there is not a purpose for individuals to say in Canada. Whereas on the right side here, for the vulnerable worker open work permit, the test is the individual experiencing abuse, or are they at risk of abuse in the context of their employment in Canada? And there is no purpose test. So I'll turn it back over to Ravneet to provide some tips on preparing these applications.
Thank you, Natalie. I also do want to say at this point that I know we've covered quite a lot of topics in immigration law. So if there are any questions at this time, feel free to raise your hand or put them in the chat. We did want to discuss some tips for filing an application for the VTIP TRP or the open work permit for vulnerable workers. The first practice that we have is to provide a lot of detailed evidence on the abuse or trafficking, whatever the case might be. So what I have here is a list which isn't exhaustive, but this evidence is helpful for such applications. The first is a sworn statement or a statutory declaration by the applicant. This is usually really helpful. I think the best idea is to include as much detail as possible, around the recruitment, the employment conditions, all of the events that happened with the applicant. It's good to provide them all in the sworn statement. You can also include other pieces of evidence as a part of that statutory declaration. So for example, if there are any email messages, any texts, or any other evidence that can be helpful to demonstrate the abuse, it's a good idea to include it in the statutory declaration as exhibits and have the applicant swear to all of it. Apart from that, it's also helpful to have any support letters or reports from any abuse support organization. If the applicant is living at a shelter, a letter of support from them could be helpful. It can also be like a report from their healthcare professional or doctor can also be pretty helpful to demonstrate the abuse and also the impact of the abuse or the trafficking, which can then go towards establishing a purpose for a VTIP TRP, for example, as Natalie was talking about. Also, I have here on the screen that hard copies of any email messages, any photos showing injuries or working conditions, any witness testimonies can all be helpful. Also, any proof of payments made to employers. So, if the recruitment was fraudulent, if they paid any recruitment fees, or even if during the employment, right, if there was any unlawful deductions or if they paid back the employer, it's helpful to provide all of that proof when you're making these applications. So, typically, of course, in all circumstances, you may not have all the evidence listed here, but it's good to provide as much as you can. If the applicant is no longer employed, we've also seen that it's helpful to file relevant complaints against the employer. So, for example, if there's a possibility of reporting it to the police and the applicant is willing to do that, then that's helpful to provide with the application. The applicants can also make a report to CBSA or Service Canada. So any copies of those reports can be provided with these applications. Even a copy of a complaint to the Employment Standards Branch, for example, is also quite helpful. And it is something that that's looked for, especially in the open work permit for vulnerable workers. Officers typically do look for other investigation reports that have been filed. If it's not provided with the application, I've seen situations where they've followed up with the request letter and they'll continue to ask you for any copies of complaints. So that's a helpful thing to do. If the applicant or your client is still working with that employer, the abusive employer, and they're afraid of retaliation, in that case as well, it's helpful to address that issue and explain why the applicant doesn't want to file complaints, and if they were able to secure their immigration status, what are the kind of applications that they intend to pursue, or what legal action do they intend to take? So it's helpful to address that issue in your submissions for such applications. Another helpful tip has been basing the submissions directly in the language of the operational guidelines that IRCC has. So IRCC has a pretty detailed explanation of the examples of what constitutes abuse, as well as defining abuse or trafficking. So if you go to the operational guidelines on IRCC website, you can see that it's quite detailed, and it's often really helpful to directly pick out those examples of the language and demonstrate how it applies to the applicant using a similar language, so that it's very evident that the client falls within the eligibility requirements for these applications. So that's been pretty helpful in my experience. Also, these applications are submitted online. Sorry, the vulnerable workers open work permit application is submitted online, while the VTIP TRP is actually mailed out to the local office. But for online applications, there are limits on the size of documents, as I'm sure you may have noticed in many immigration applications. So the limit is pretty small. I think it's around 4 MB. So I think it's important to make sure that the quality of the documents hasn't reduced, especially when they're photos or they're copies of other documents. So it's a good idea to make sure that the quality is clear. If it doesn't all fit in through the GCK account, I've also used the web form to send additional documents or to send better quality documents if required. So that's a helpful tip as well. Also, if there are any supporting documents in languages that are not English or French, for example, if there are text messages that are in another language, it's important to get them, have an official translation of the original document. Immigration will not accept any unofficial translations or look at any documents that are not in English or French. So if you don't provide that, that can lead to delays. So they might send you a request letter. So it's helpful to just do that while you're applying in order to make sure that the application is processed quickly. Also for these kind of applications, there is the possibility that there would be an interview by phone or in person. But in my experience, I've seen that they've been quite rare since COVID-19. There were before COVID-19, so I think before May 2020, there were some interviews that IRCC was conducting, but that I haven't seen that since the pandemic. When interviews were conducted, often applicants were required to provide their own interpreter. So there is the possibility that IRCC may provide them, but I didn't see that in the applications around that time. Most of the times, the interpreter had to be provided by the applicant, and so the applicant had to pay for that. So that's a consideration to keep in mind while making such applications. Also, representatives aren't usually welcome to attend interviews. They can only be there sort of as to clarify any answers of the applicant. They can't really act as counsel. So they're just there as a support or to sort of clarify the answers of the applicant. So this is what we've seen in our experience. If there are any other questions that you have based on your experience in making these applications, feel free to put them in the chat. And just to, I also just want to quickly discuss the one option that does exist, a permanent solution that does exist for temporary foreign workers. So there isn't any specific pathway to PR for victims of trafficking, but they can apply for permanent residence based on humanitarian and compassionate grounds. So this is so this application is one pathway that's available. Some of the factors that are relevant for these applications can be adverse conditions in the home country, any health considerations that the client has, their establishment and ties to Canada, the best interest of any children that are involved, and any other unique, exceptional circumstances that are applicable. They can all be relevant when making such a PR application. But of course, while this application, so as I say on the slide here, the client their status does not get regularized until they receive first stage approval. So if a client makes an application for PR based on agency grounds, they'll have to wait for the first stage approval before they can get access to an open work permit, so any work authorization or healthcare or social assistance. And getting this first stage approval can often take a long time. I've seen it take up to a year. So there is that wait where clients will not have access to legal status in Canada. So that's something to be aware of. But this is one permanent protection that exists for clients who may have faced abuse in their employments. We're going to switch gears and move to some other common immigration issues. I want to start off by discussing what is a representative as understood by IRCC. So according to through an immigration lens, a representative is someone who explains or gives advice on immigration or citizenship options. They could help a person choose the best immigration program for them. They could fill out and help them complete their application to IRCC. The representative could also communicate with IRCC on the applicant's behalf, and they could represent the applicant in any sort of a hearing or an application. So that's how a representative is defined by IRCC. But there is not every part of helping a client makes you a representative. If someone is just helping a client use the immigration website to find information, or if someone is helping them access a computer, access some forms on the immigration website, or to navigate the IRCC website, then that doesn't make someone a representative. So that there is a distinction here between what is typically, what would be considered actions that make you a representative and some that don't. I now want to discuss the two types of representatives as well, just to provide a clear picture of how immigration looks at it. The first type of representatives are uncompensated representatives. So they do not charge any fees and they don't receive any compensation from the applicant. So uncompensated representatives could be friends or family members of the applicant, or it could also be lawyers or consultants. The second type of representatives are ones that are compensated. So if they're the ones who charge a fee or they receive some other kind of consideration in exchange for the representation that they're providing. So compensated representatives necessarily need to be either immigration consultants, so those consultants who are members of the ICCRC, or they need to be lawyers or paralegals or articling students under the supervision of a lawyer. So there is this distinction that if it is someone like a third party, a random third party who is being compensated but is not a consultant or a lawyer, I mean, that shouldn't be the case. They are not. They are supposed to be consultants or lawyers, only though they are authorized to be compensated for their services. And in those situations, the applicant must also provide, declare that to immigration. So there's a specific form. It's called the IMM 5476. That's a form that the applicant would need to fill out and enter in all the details of their representative. So that form allows IRCC to know who the representative is, and paid representatives must necessarily provide that form. So the issue of representatives becomes relevant, when we're assisting clients, because if you're providing advice to clients, advice such as what program to apply for, or you're helping them complete their application, or you're dealing with immigration on their behalf, then you are acting as their representative and you would need to disclose that to IRCC. Applicants are responsible for all the information in their application. So even if there's a representative or any person who's helping them, the responsibility is always on the applicant. Therefore, it's really important to be mindful when we're helping clients with immigration issues. For example, even if you're helping them out with a form, and if there's an error in that or in their application, that could make the applicant is responsible for that error, even if the representative makes it. So that's something to be mindful of when helping clients with their immigration issues. But also, if you have a client who's getting immigration advice from third parties, I think it's also important to sort of warn them about some of the issues surrounding representatives. So if your clients have a paid representative, it is important advice to tell them that representative should be registered either as a consultant or as a lawyer. So you can always look that up on directories that are publicly available. For example, the Law Society of BC has a list of all the lawyers. So it's really helpful advice to inform the clients to go check that their representative is on those directories, because often some representatives might not be registered and they may not disclose that to your clients. So it's a good idea to advise them to go and look at these public registries, because if the paid representative isn't registered, then that's a big red flag. And so clients need to maybe rethink what to do next. So that's just some advice surrounding representatives for immigration applications. I will now turn it over to Natalie to discuss some other common immigration problems.
Yeah, so one of the common immigration problems that we see quite frequently at the Migrant Workers Center is around the issue of unauthorized work. So unauthorized work is essentially doing any work without the required immigration authorization. So it includes working in Canada without a valid work permit, or working for a different employer or a different job than that which is stated on the worker's work permit. So if a worker is found to have engaged in unauthorized work, they will by default lose their status in Canada. And if a worker has been doing unauthorized work, we really encourage them to seek legal advice. They may be eligible to restore their status if they have done unauthorized work. In certain situations. So IRCC allows temporary foreign workers to restore their status, generally speaking, within 90 days of losing their status, and applications for restoration are made through a new work permit application. So some examples that we see of workers doing unauthorized work could include things like, if a worker, has lost their employment in Canada and they're looking for a new job, and they meet a new potential employer, and that employer asks them to do a trial period to make sure that they're a good fit for the position, or if they're asked to do a training period prior to them actually receiving work authorization, then that would be considered unauthorized work. Another example, of course, is if an individual holds a work permit that authorizes them to work, let's say for a particular restaurant in a particular position. So if they're working for a restaurant as a cook, and then actually the work that they are performing at that restaurant is not as a cook, but rather as a host, that would also be considered unauthorized work. So if an individual is found to have engaged in unauthorized work by the Canada Border Services Agency, that could be grounds for them to be referred to an admissibility hearing to determine whether that individual is admissible to Canada or not. And if it is found that they have violated the provisions of their work permit by performing unauthorized work, it could lead to them being removed from the country. So we really do encourage individuals to get legal advice about whether they are eligible to restore their status or not. It can be a little bit of a complex area to sort of help people determine whether they are eligible or not. So that's unauthorized work. We'll go now to misrepresentation, which is another common issue that we see coming up for temporary foreign workers, which can also lead them to being found inadmissible to Canada. So under the Immigration and Refugee Protection Act, the threshold for misrepresentation is quite broad. A permanent resident or a foreign national can be inadmissible to Canada for misrepresentation if they directly or indirectly misrepresent or withhold material facts relating to a relevant matter that induces or could induce an error in the administration of this act. And if a worker is found to have engaged in misrepresentation, they can be removed from Canada, and they can receive an exclusion order that bars them from being able to return for a period of 5 years. So the penalty is quite severe for someone who has misrepresented information to immigration. And this, misrepresentation can include, unintentional misrepresentations as well. And as Ravneet mentioned earlier, if someone is working with a representative who has misrepresented information on an immigration application form, for instance, and the client did not take the time or was not given a copy of that application to review for themselves, it will still be the responsibility of the applicant. And they could be found to have committed misrepresentation in that kind of situation. So some examples of misrepresentations include declaring false employment information, for instance. So if an individual is applying for a new work permit under the Temporary Foreign Worker Program, on the form itself, they are required to list their employment history. If they've omitted to include periods of work where they were working in doing unauthorized work, then that would be considered a misrepresentation. And so if immigration were to find out about that period of employment later on, it could be, unfortunately, something that could be investigated and acted upon by the Canada Border Services Agency. If an individual provides documentation with false or erroneous information in it, we sometimes see this with documents from another country that may have, an incorrect or false, date on a document, for instance. Even unintentional misrepresentation such as this can be found to constitute misrepresentation. We also see it fairly commonly with individuals who do not properly declare their marital status on entry to Canada. So we've had clients, tell us that, an immigration consultant or representative had, advised them not to indicate that they were married on their applications to Canada. For instance, when in reality they were married, or we have seen individuals indicate that they are married when actually they are separated. And so it's important to try to address those issues around someone's marital status before they apply for permanent residency, because the misrepresentation will become material in the context of a permanent resident application. And this can also happen with failing to declare a dependent, for instance. So if someone submits an immigration application and does not include, children, a stepchild or an adopted child, for instance, that could also be considered misrepresentation. So it's really, really important that individuals obtain legal advice. If you think that they have provided any information to immigration that is not 100% accurate.
My apologies there, I skipped ahead. But yeah, now that concludes most of the topics we wanted to discuss on immigration law. And we'll now be discussing some of the employment law issues that are relevant for temporary foreign workers. So before, I just want to talk briefly about the different areas of employment law in BC and the different organizations that are responsible for them. So first of all, there is the Employment Standards Branch, which is responsible for enforcing, which is responsible for dealing with any complaints that have to do with minimum standards of work as laid out in the Employment Standards Act. For when we're talking about issues of workplace safety or injuries or any sort of bullying or harassment, it usually falls within the mandate of WorkSafe BC. There can also be associated human rights issues. So any sort of discrimination they can be complaint made about that to the BC Human Rights Tribunal. And of course, any sort of employment contractual remedies or violations are dealt by the courts. And Service Canada is responsible for any issues to do with employment insurance or ROEs, which can also come up for temporary foreign workers. So today we'll only be discussing the Employment Standards Act and not some of the other areas that I just mentioned. So just as an overview of the Employment Standards Act, it establishes the minimum standards for wages, hours of work, holidays, termination, and other working or employment conditions in British Columbia. And as I mentioned, the Employment Standards Branch is responsible for administration of any complaints under the ESA. The Immigration Standards website is a really helpful website. It contains a lot of information regarding the rights of workers. It also includes fact sheets that talk about various industries, and also the complaint form is available on the website. So clients would need to use the complaint form if they want to file a complaint with the Employment Standards Branch. The really important thing about the Employment Standards Branch is that clients only have 6 months in order to bring a claim. So the time limit here is extremely short, but that is the time limit. And a lot of times temporary foreign workers are not aware, and then they miss out on this remedy. So it's important to keep in mind that workers only have 6 months to bring a claim. And if they are making a claim for unpaid wages, then the recovery period is limited to the 12 months prior to the complaint. So there are those limitations that the Employment Standards Act has. Further, if they typically a worker would make a complaint to the Employment Standards branch, and if there isn't a settlement, then there would be an investigation and then a determination. That determination can be appealed by the employer or the employee, and they can appeal the decision before the Employment Standards Tribunal. So that's the appellate body responsible. Also, if there is a determination and the employer is ordered to pay some money as unpaid wages or whatever else, and if the employer does not pay that within the specified time, then the matter goes to ESB for enforcement. So they have various means of collecting on that. So they can take various collection action, like there could be a lien on their property or funds. So the Employment Standards branch also deals with that aspect. Moving on now, I have briefly on this slide who is covered by the Employment Standards Act. So most employees in BC are protected by the Employment Standards Act, and an employee is anyone who receives or is entitled to receive wages for work that they've performed. So this protection by the Employment Standards Act is not dependent on their immigration status. A lot of times temporary foreign workers will think that because they've lost status or because they were doing unauthorized work, they believe that they're not protected by the Employment Standards Act, but that is not the case. So employees that are, if they are working in BC, they are protected by the Employment Standards Act, generally speaking, unless they fall within some of the exclusions. So some of the exclusions under the Employment Standards Act are, there's some occupations that are completely excluded. For example, I have on the slide here, architects, lawyers, accountants, sitters, they're completely excluded from protections under the Act. There are also certain other employees that are excluded from certain protections of the Employment Standards Act. So, for example, farm workers are excluded from the protections for overtime work. Also the federally regulated businesses and industries and also independent contractors are also excluded from the Employment Standards Act. Workers that are a part of the union, they may have some protections, but they have to seek recourse for that according to the process that's being laid out in their collective agreement. So these are typically, this is just an overview of who is covered by the Employment Standards Act. But as I mentioned, there could be exclusions. So it's important to check the regulations to actually make sure whether your client falls within the Employment Standards Act or not. So broadly speaking, the Employment Standards Act has rules that pertain to a lot of some of the issues under a worker's employment. So I have on the screen here what the rules cover. It includes recruitment and hiring of the workers. It includes wages, so minimum wages, the payment of wages, and any deductions. The Employment Standards Act also governs, overtime hours and breaks from work. It also does provide for statutory holidays, vacation pay, and vacation days. And it does also have rules surrounding how employment can be terminated. And so all of those provisions are in the Employment Standards Act. I will turn it over to Natalie to discuss some of them in a little bit more, in some more detail.
Yeah, so before we talk about some of the common Employment Standards Act violations that we see with our clients, I just wanted to cover some of the recent changes to employment standards with respect to leave that is related to COVID-19. So the government of British Columbia brought in some new leave provisions as a result of the pandemic. You may have heard of these in the news. So the first one is the COVID-19 vaccine paid leave. So this is a leave provision that allows employees to receive 3 hours of paid leave from their workday to go and receive a vaccination against COVID-19. There is also COVID-19 paid sick leave. So this allows employees to take 3 days off work of paid sick leave. And this applies between the period of March 20th, 2021 and December 31st, 2021. So it will expire at the end of this year. If the employee is unable to work for any of the following reasons, if they've received a diagnosis of COVID-19 and are instructed to isolate, if they are in quarantine or self-isolation as directed by a health professional or public health, or if they're directed by their employer not to work due to COVID-19 related reasons, they can be entitled to have 3 days off of paid sick leave. Now, there is, in addition to this, COVID-19 related unpaid job protected leave. It could be that an individual is required to quarantine or self-isolate, for instance, for a period that is longer than 3 days. They would only receive paid leave for 3 days, but they would be eligible to take additional unpaid leave for as long as they need, depending on the reason for their leave. And this leave is job protected, meaning that an employer cannot terminate an employee for taking leave related to COVID-19. So some of the reasons for taking this unpaid job protective leave include the 3 that apply to the paid sick leave, but it's also broader. If an individual is having to provide care for a dependent who has been diagnosed with COVID-19, for instance, they can avail of unpaid leave. And there is a list on the Employment Standards Branch website of all of the situations that would be applicable here. So if you do have clients who need to take leave from work, it would be helpful to just make sure that that they are actually eligible for it, because if they aren't, they would not necessarily have protection from being terminated from their jobs. So starting with the next slide, I'm just going to cover 3 of the sort of common, more complex issues that we see with employment standards. We file numerous employment standards complaints on behalf of temporary foreign workers each year. Often our complaints are on the basis of unpaid wages or unpaid overtime wages. However, we also commonly see claims that are based on Section 8 here, which is the section that prohibits misrepresentation of jobs or job offers by employers. So under this section of the Act, employers cannot influence a worker to accept a job by misrepresenting the availability of a position, the type of work, the wages, or the working conditions. So for temporary foreign workers, unfortunately, we do see situations where jobs are misrepresented. We see cases where temporary foreign workers are hired for jobs, travel to Canada, and then are told that the jobs no longer exist. And then we also see situations where a temporary foreign worker is hired for one job and then they're actually asked to work in a different job. So if that is the case, workers can file a complaint based on Section 8, and this is one of the only make-whole remedies under the Act, which means that workers can recover expenses related to the misrepresentation. So if they've had expenses including things like travel expenses. In order to take up the job, they can seek reimbursement for those. And they can also seek reimbursement for lost wages according to the employment agreement or offer. So for instance, if a worker is hired for a job and then later finds out that it does not exist, they can file for lost wages up until the moment in time when they're able to secure a new job, minus reasonable mitigation, of course. The next situation that we see commonly is with respect to recruitment and hiring. So often we see temporary foreign workers who are charged illegal recruitment fees for jobs. This is illegal both under Section 10 of the Employment Standards Act and under Section 21 of the Temporary Foreign Worker Protection Act, which I'll talk about briefly in a moment. So lawyers and immigration consultants can charge fees to workers for assistance with their immigration applications. So if a worker is coming to work in Canada or is in Canada and is changing jobs, and they seek help with that process, lawyers and immigration consultants can charge fees for, consultations or for assistance with, reviewing a work permit application, for instance, but they cannot charge a fee related to placing them into a job or connecting them with a new job in Canada. We often see immigration consultants who are sort of in a dual role as recruiters and immigration consultants and charging very high fees for their services, sometimes upwards of $40,000. And so this is, an issue that continues to take place in BC, despite the greater protections that are now available under the Temporary Foreign Worker Protection Act. And the third area that we commonly see is deductions from wages, so unlawful deductions. So for instance, under Section 21, the only deductions that employers can legally make from an employee's wages are for income tax purposes, for CPP or EI premiums. If there is a written agreement, and it has to be a written and signed agreement, employers can also make deductions for room and board or money that the employee borrowed from the employer, but for no other reasons. Deductions cannot be made for business-related costs, such as, if a worker is working in a restaurant and breaks some dishes, they cannot, have their wages deducted for that. In the case of temporary foreign workers, what we often see is what happening are indirect deductions, where an individual worker is, receives their paycheck, goes to the bank, cashes their paycheck, and then they're asked to return a portion of their wages back to the employer in cash. And so that is absolutely, an illegal deduction and is considered a deduction under the Act. And then I just quickly wanted to touch on the Temporary Foreign Worker Protection Act. Again, this is a topic that could be the subject of a whole presentation in and of itself. So I just wanted to share some of the highlights here. The Temporary Foreign Worker Protection Act, as I mentioned at the outset, is relatively new legislation in BC, and it applies to employees who are here under the Temporary Foreign Worker Program, or the Home Child Care Provider Pilot, or the Home Support Worker Pilot. The Act contains provisions that prohibit some of the more common abuses that we see taking place of temporary foreign workers. So for instance, taking the passport or documents from the worker, misrepresenting employment opportunities, threatening deportation, retaliation for participating in an investigation or complaint, or the charging of recruitment fees for jobs. So under this Act, recruiters must apply for a license from the province, and they must pay a security at the time of doing so. Employers of temporary foreign workers must also now register with the province. The legislation has been fully in force for about a year now, so since September 17th, 2020. So its provisions would only apply to violations that have occurred after this date. So we are just starting to see workers coming forward now who've paid recruitment fees after September 17th, 2020, and seeking to file complaints on that basis under this act. The nice thing about the Temporary Foreign Worker Protection Act is that the limitation period for filing complaints has been extended to 2 years. So as Ravneet mentioned, the 6-month limitation period with the Employment Standards Branch for the Employment Standards Act is only 6 months. And, part of the reason why we advocated for this new law is because we were seeing a lot of workers who were paying illegal recruitment fees for jobs and then did not have recourse under the Employment Standards Act to recuperate those fees because they had paid them, prior to 6 months of coming to Canada. Often recruitment fees are paid, over 6 months or even over a year before workers even set foot in the country. So it was proving to be ineffective for our clients. So under the Temporary Foreign Worker Protection Act, workers will follow a similar process for employment standards complaints. They will fill out the same form, but they will check off on the form that they are actually filing the complaint under the Temporary Foreign Worker Protection Act, and they have a 2-year limitation period. Now, one of the things that I've found helpful, if we could just go back, thanks, is that there is a list of the licensed recruiters that are published online by the BC government. And this is a live list that is accurate, and it can be a good resource for workers who are looking to change employers or who are looking for a new job, because it provides a list of recruiters who have gone through the process of being vetted by the BC government to be recruiters, have paid a security, and are required to follow all of the requirements under this act. So we will often refer people to this list if they are looking for a job, so that they can contact the individual recruiters to see if they are in fact recruiting for workers.
So now I'm just going to go back and discuss how to file a complaint with the Employment Standards Branch. So as I was mentioning previously, there is the complaint form is available on the ESP website, and so the complaint can be filed online. Once the complaint is filed, there is the possibility of voluntary resolution between the employer and the employee. If that does not happen, then the complaints proceed to investigation. And so that's what, and they do not, there has been no mediation or oral hearing anymore. In fact, there is an investigation by one of the industrial relations officer. So they will investigate on both sides and maybe ask for more evidence or documents from the employer as well as the employee. They might have interviews over phone recently due to COVID-19 with the employers and the employees to gather evidence. So that's been the process of the Employment Standards Branch of late. Complaints are being, they're being investigated rather than having a hearing or a mediation. ESB officers will also review payroll records when they're investigating a complaint. So if there's an issue of unpaid wages, then they could ask the employer to provide their payroll records. So it's a little bit of a flexible process where the investigator can ask both sides to provide any kind of evidence or to answer any questions that they may have about the complaint. What I also have on the slides here, and which is an important point to keep into mind when making a complaint to the Employment Standards Branch, is that when a complaint is made, the branch may alert the employer about the complaint. And in those situations, a lot of times temporary foreign workers are concerned about any retaliation by the employer, especially if they've done any sort of unauthorized work. So clients are often worried, and it's a fair concern that the employer may retaliate and call the CBSA tip line and report them for any unauthorized work that they did. So, if that's possible, it's important that clients disclose their unauthorized work and apply for restoration. That would ensure that the immigration status is secure and that they're not concerned about any retaliation. But of course, as I said, we have to keep in mind the 6-month deadline if the complaint is being filed under the Employment Standards Act. There is the possibility in the Employment Standards complaint form to ask them to not disclose that, to not disclose the complaint to the employer. So that's something that that can be discussed with the worker in order to ensure that they don't face any retaliation from their employers. Next, I want to discuss some best practices for filing a complaint with the Employment Standards Branch. I have been talking about the 6-month deadline, but because it's such a short deadline, but that's of course something to keep in mind. If a worker is approaching their deadline and there hasn't been enough time to gather all the evidence, the complaint can still be submitted online. So the form can be filled out online, and the evidence and more details can be provided at a later point of time, but it's important to not miss the deadline. Also, it's also important to make it clear in the complaint submission if the number of hours that the client has worked are an estimate. So a lot of times workers will, there can be two possible cases. Sometimes workers will have an actual record of hours. So maybe the temporary foreign worker has been maintaining their own journal or a diary recording exactly their hours of work. So in those cases, that evidence must be provided with the complaint form. But sometimes, workers or employees don't actually have such a record, and they have an estimate that typically we work from 9 a.m. until 7 p.m. every day. So if it's an estimate, it's important to mention that the hours are an estimate and it's approximate because, as I mentioned, during the investigation process, the ESB officer is making credibility assessments about, with respect to the employee and the employer. And that credibility assessment is also based on any documentary evidence that's provided. So whether that's provided by the worker themselves or by their representative, there is the credibility assessment. So it's important to make a note if it's just an estimate or if it's approximate. Also, it is important to provide evidence to substantiate all the claims or the violations that have happened. So that would include, if there's a recruitment fee that was charged from the worker, then any evidence about the payments made, any sort of receipts of bank transfers, screenshots of electronic transfers, all of that can be helpful. With respect to unlawful deductions, as Natalie was mentioning, a lot of times workers will be paying that in cash, but sometimes there could still be a pattern. For example, maybe they're withdrawing a certain sum of money every month right after they deposit their paycheck. So that can still be helpful evidence, and it's important to provide that to the branch. Also, another evidence that can be provided is a sworn statement from the worker. So if the evidence in the complaint is lacking and a lot depends on the statement from the worker, it may be a good idea to provide an affidavit or a statutory declaration that would affect the weight of the evidence. Also, I've also mentioned here that don't assume that the ESB officer will be looking for all the violations. So yes, typically they are supposed to conduct an investigation and look into all possible violations of the Act. That may not happen. So it is important as the advocate to highlight any violations that have occurred. Some of those violations may not have a monetary or a financial remedy for the worker themselves. For example, if they haven't been paid proper wage, if they don't have proper wage statements. But it's still important to highlight them as violations that the employer has committed. Another example would be if the worker hasn't been paid bi-weekly. If they haven't been paid bi-weekly, that's a violation of the Employment Standards Act, and it's a good idea to mention all those violations, apart from just the ones that are a financial remedy for our client. So these are just some of the tips that we found helpful. Now on this slide, I've just mention what are the documents that should be included with an employment standards complaint. The first would, of course, be the complaint form itself, which requires details about the employer, the employee, and the violations. You can also, if you're acting as a representative, you would provide a representation authorization, which would be signed by the client. You could also include the client's work permit, a redacted version to support the fact that they worked for this employer. You can provide any employment contract or even the labor market impact assessment if it's a temporary foreign worker who doesn't have another employment contract. It's also helpful to provide a record of hours that the client worked. So as I mentioned previously, sometimes the workers might have a handwritten record that they've maintained that can be really persuasive evidence. But if they don't have that, you can provide an estimate as well, stating that it is an estimate. Also, the client's bank statements can also be helpful, as I was explaining. Any pay slips that they have or copies of checks that they've received as payment. Also, any other documents that prove that they did that work, right, or that support the claim. So, for example, it could be, photos of different work sites if that's relevant, or sometimes clients will have photos of their schedule. If, for example, if they're working at a restaurant, they'll have their weekly schedules and they might take a photo of that. That can be helpful. So there isn't any set criteria. This is nowhere close to being an exhaustive list. It all depends on the specific circumstances of that case. But it's, I think the Employment Standards Branch does provide a bit of flexibility that you can provide a lot of different kinds of evidence. So even text messages, I've also provided text messages with unofficial translations, and the ESB officers have looked at that. So yeah, those are all some examples of documents that you can include with the complaint. And also you can include the calculations of the amount that is owed to the complainant. And that total would, of course, would be the gross total, and without the deductions. It's helpful to provide that as well. Now I have here on the screen just the website for the Employment Standards Branch. I've been talking about how helpful it is, and it has a lot of information that can be helpful for temporary foreign workers. They also have a toll-free line where workers can ask any questions that they have about their protections under the Employment Standards Act. So those details are here just as resources for your clients.
So keeping a detailed record of a worker's employment is really, really quite critical and helpful if workers have experienced abuse, or even if they haven't experienced abuse and things appear to be going well. It is still good practice to encourage employees to keep records of their jobs. So we always encourage workers to keep a diary or a calendar and just jot down the dates, times, and locations where they worked. If they could also provide a description of their tasks and any incidents that may have happened at work, that could also be helpful. If there is an incident at work, just making note of any witnesses who may have been there. And if the employee contacted other people for help or organizations, to keep a written record of who they contacted, what that person said, and if any action was taken. It can also be really helpful evidence to have, instructions from employers or other communications from employers in the form of things like text messages, as Ravneet was mentioning, emails, voicemails. Keeping copies of those can really be helpful for substantiating claims later on. And photos as well, photos of the workplace that indicate, the time that the individual was working, particularly if they're claiming for overtime, can also be really helpful. So in addition to these records, also I would also add, records of employment, wage statements issued to the worker, and copies of their paychecks as well can also be really helpful evidence. And then finally, we just wanted to share a resource with you all. Some of you might have already worked with the Salvation Army Illuminate. They are a program within the Salvation Army here in Vancouver that provides quite critical supports to individuals who have experienced labor trafficking or labor exploitation. We've worked with them for a number of years. They operate a safe house called Deborah's Gate for women who've experienced trafficking, and they include women who've experienced human trafficking for sexual exploitation as well as for labor exploitation. But they also have navigators outside of the safe house who can provide case management support for workers to support them in safely exiting from a situation of exploitation. They can connect people with psychosocial support and case planning for their recovery. They can provide access to counseling as well as support for criminal and civil justice processes. They even have funds to pay for counseling, which is incredible. They really have a focus on providing services during times that workers are more likely to be available, so after hours and on the weekends. All of their services are voluntary, non-religious, and free of cost, and they can also provide coverage for translation. So we work very closely with them. A lot of our clients come to us for services because they've experienced abuse. And we as lawyers and legal advocates here at the Migrant Workers Center, we are, limited in terms of the type of support that we can provide. And we often find that the psychosocial support is really critical for individuals to be able to, access the social services that they need, which in turn helps to position themselves more favorably to actually be able to pursue legal complaints. And so we work with the Salvation Army quite closely. We've provided their contact information here. It is a program that's available across Canada. And they've been so helpful to us in many ways. Like, for instance, we've had cases where, migrant workers have shown up in our offices because they've just left an abusive employer and they have nowhere to stay that night. We will get on the phone with one of the navigators and they will find, a shelter for them to stay in and look for longer term solutions as well. So we just wanted to share that, this resource. We think they are really providing really important services. And I think that concludes the presentation. We'd really love to open it up to questions. We actually have not received any questions at all in the chat. So I know we've covered a lot of information today. You may still be kind of absorbing it, but if you do have any questions or clarifications, we'd be happy to open it up now to you to ask anything that you'd like. We do have a question. I'll just read out the question. So I have a question regarding workers who do not want to have the double vaccine. I heard that they can take no paid leave, but can they lose their position? So the question is whether a worker could be terminated if they refuse to be vaccinated. I think that might be the question. Yeah, that is a complex question. Yeah, I think that's a question that, many employers, including the federal government and provincial governments and unions all across the country, are dealing with at the moment. And I don't think that there is a clear legal answer at this stage. We know that there have been some industries and sectors where there is a mandatory vaccine requirement. I'm thinking of, the long-term care sector in BC, for instance, as one example, some healthcare providers as well. But this is a really hot issue right now in the employment law field around whether, the legality of mandatory vaccine mandates. So I would sort of lean towards saying that a worker at this stage, if they are not in working in a sector where there has been a mandate for vaccines, that they likely would it would not likely be legal for an employer to terminate them on that basis. But again, this is, I think, kind of a bit of an open question if there is indeed a vaccine mandate. I don't know if you have anything to add to that, Ravneet.
Yeah. I mean, not much. I agree with you that it is an open question. And like often I tell my clients that there's nothing to prevent them really from terminating your employment. I mean, they can do that and it will be open. We'll have to see what remedies they might be able to access. So I think we'll only see when people make complaints or when the court deals with it on whether they award damages or not is something we'll have to wait and watch. Yeah.
And that is an area that we didn't cover today in the presentation, is that there are provisions under the Employment Standards Act around, minimum notice of termination of employment and or of severance pay. So as Ravneet said, an employer can terminate an employee's employment at any time, provided that they comply with those minimum notice periods that are in the Act. However, it also gets a little bit more complicated when we can factor in, provisions that might be in the employment contract that may be different than what is, stated in the Employment Standards Act. So if people are being terminated from their employment, again, we would just really encourage them to seek legal advice around what they might be entitled to in terms of damages. If you go to our website, you'll find that there are numerous fact sheets that we developed in the context of the pandemic that provide, some basic information on different employment rights and different policies and programs that have come into place during the pandemic as well. Most of them are still up to date. Some of them need to be updated, but we've included the date that they were last updated on each individual fact sheet, so that if something hasn't been updated since the spring, it might be a good idea to just verify the information before providing it to your clients. And then we also encourage you to follow us on Facebook. We share a lot of updates and information via social media these days.
So let me take a moment and thank Natalie and Ravneet for taking the time to do a very in-depth and thorough presentation. Thank you so much. And then I also